Okay, we will get started. Thank you everybody for joining this webinar today. Many of you already know our two speakers, so my introductions will be very brief. The truth is, if I tried to do either of them justice, it would take all the time we have, so all the more reason to be brief. First, we have Marshall Tannick, who has represented clients for Matter. I'm going to go ahead and say now, please mute your mics, because we will hear anything going on if your mic isn't muted. So I'll go back to starting my introduction now. First, we have Marshall Tannick, who has represented clients in a wide variety of legal matters for 45 years. He is also a contributing columnist for Minnesota Lawyer and a frequent CLE presenter on a range of legal issues, including basketball and hockey, and even today's topic, the U.S. Supreme Court. Next, we have David Schultz, who was recently named Distinguished University Professor of Political Science at Hamline University. Along with teaching at Hamline, Professor Schultz also teaches election law at University of Minnesota Law School and Mitchell-Hamline. Professor Schultz is also well known for his many publications and as a regular political commentator on local and national news, particularly on election nights, which we all look forward to. A couple of last things, as I said before, please make sure your mics are muted throughout. It really can be disturbing for others if they're not. And I also invite you to type questions into chat, and we will make sure that the speakers get those. And with nothing else, then I will turn it over to our speakers.
Great, thank you very much. And this is David Schultz. I'm going to go first, and hopefully you all can see the PowerPoint that I have here, and it's called the Overview of the 2019 Supreme Court Term. And I will just sort of, go from there. Right. So what I want to do in my part of the presentation, go for about 25 minutes, is kind of do an overview. And I know that some of you are used to just having people talk through the cases and talk through what the court said, and I'll do a little bit of that too, as will Marshall. But I also like to do, in terms of my overview, to try to give us a sense of the flavor, almost like the biorhythm of what was happening, and some of the big issues to think about from the term that just ended, and a little bit of sort of thoughts in terms of thinking ahead regarding what we should be looking toward now that we're past the first Monday in October. The Supreme Court is within its new term. So on this second slide here, observations and highlights, things that we need to think about from the past year is obviously it was the exit of Anthony Kennedy and the entrance of Brett Kavanaugh. Kennedy was many ways a somewhat swing justice for many years, maybe one of the most influential swing justices, at least in recent history on the court. And at the time when he stepped down and Brett Kavanaugh replaced him, it was viewed that this was going to push the court further to the right, that it was now going to endanger major precedents such as Roe versus Wade or other critical precedents. And we're going to talk a little bit about that, because it's not so clear on the face of it how much that he accomplished. But again, we're going to look at some numbers, and I'll come to some conclusions regarding what Brett Kavanaugh's actual impact was. Thus, did the court move to the right? I'm going to say yes, it did. We did some indications. We're also going to see that as the speculation emerged, that to some extent Justice Roberts did emerge, Chief Justice Roberts, I should say, did emerge as somewhat of a new swing role. That as Chief Justice, he has to worry about the perceptions, the legitimacy, of the institution. And for some of us who saw the Chief Justice over at Northrop Auditorium, 2 or 3 years ago, you get the sense that, while he clearly has political orientations, he's also worried about his place in history and the role of the court in history. So it's possible that he did become more of a swing, and we're going to look at that. Also, one of the most interesting things that I think that happened this past term was the Supreme Court went remote. And specifically, there were a series of 10 cases that got delayed because of the pandemic. And as a result, the Supreme Court did oral arguments by telephone and remote. And we're going to talk a little bit about what that means. And for those of you who are maybe just court observers, or perhaps for those of you who are appellate attorneys, I think some of the things that we learned were important. And then I was also thinking, as we were entering, and we were all admonished to make sure that our cell phones are turned off. We're going to talk about what I'm going to call the supreme flush for a second here, an unexpected noise during one of the oral arguments, a little bit of an assessment of the Trump impact so far, and then, of course, although it didn't happen last term, when I first did this presentation a few weeks ago, unfortunately, one was speculating on how long Ruth Bader Ginsburg would last and what would happen. And of course, as we know, unfortunately, she passed away. As we speak, the debates are going on regarding her replacement with Amy Coney Barrett. And we have to think about the impact for the election. And then, of course, down the line, cases that she will participate in this term or a future term regarding, among other things, the constitutionality of the Affordable Care Act, i.e. Obamacare. No doubt there's going to be a new reproductive rights case coming up at some point, and a host of other cases we may want to think about and assess what her impact might be. Now, I always like to start off by pointing out also that one of the great jobs of having the United States as Supreme Court Justice, when you think about it here, once you get confirmed, you're tenured for life and you can't have your pay decreased at all during that time. That's even better than being a university professor in some ways. And what we know is, or want to figure out is, where does the workload, what's the workload of a justice like? And if we went back to the 1970s, the Supreme Court was getting about 4,000 to 4,500 cert petitions every year, and it would grant about 350 to 400 of them to eventually issue merit opinions. So that's an interesting ratio. About 4,500, again, roughly it's set at that point, about 350 to 400 merit opinions. Now the Supreme Court is getting between about 7,500 to 8,000 cert petitions every year. But what's happening? And I just wanted to give you a couple of comparisons here. In the 2019 term, 61 merit opinions were released. There were 53 orals, 2 per curiams, 5 summary reversals. And it would be easy to conclude and say, well, this is just a result, this incredibly low number of the pandemic. The courts really not working that little bit, are they? Well, do a comparison to 2018. 72 merit opinions released, 66 opinions after orals, 1 per curiam, 5 summary reversals. Yeah, it's down this past year, but it's a trend that we've been seeing for several years, especially under the Roberts Court. Now, some can say that maybe the Roberts Court is getting more selective in its opinions, and that's a possibility. Some might say that with a variety of their decisions, whether it ranges from class actions to facial challenges to questions about jurisdiction and standing, that it has made it more difficult to get through the courthouse door to get to the Supreme Court. That is probably accurate too, that it is just harder to get in. But nonetheless, when we look at my math is not good off the top of my head here, 61 merit opinions out of about 7,500 to 8,000 requests, for cert petitions, the odds are pretty low that you're going to get your case accepted by the U.S. Supreme Court. So if you've been lucky enough to have that happen, you've kind of hit you've grabbed the brass ring in life. Case composition, 100% cert, and this is important because sometimes there's an occasional case that comes on original jurisdiction. The Constitution lays out a finite number of cases that must originate there. None this year. In a good year, you might find one. A couple of years ago, there was one year that there was 2. These are usually wonderful cases, like, for example, my favorite one recently was Tennessee versus Georgia. And they were fighting over the boundary line. And the argument by Georgia was that the Tennessee River had now dipped below the latitudinal line separating the 2 states, and therefore the Tennessee River was completely within their state, and therefore they could drain all the water they wanted for Atlanta and for a very thirsty population. Those are just great cases to have, but none of those this term. 82% from the U.S. Court of Appeals, 18% from state courts, 87% paid, 13% pauperous. And again, I find this significant because the decreasing number of cases, and I could have put comparisons in here in terms of pauperous cases, is disturbing. Disturbing because for people who are prisoners, for example, for people who are oftentimes indigent but nonetheless seek to have their rights vindicated, this relatively small percentage of pauperous makes it a concern about whether or not there is equal justice for all before the Supreme Court. And then again, the next set of numbers, and note there's probably some rounding errors here, or rounding issues here. 79% civil, 17% criminal, 3% habeas. Relatively consistent in terms of where the court has been. Case dispositions, I like looking at this because it tells us of the cases that were decided by the Supreme Court, where did they come from? What was the lower court before they came up? And it just tells us some interesting patterns here. And I hopefully you'll all have a copy at some point of the PowerPoint, because I don't know how well this comes across some of the print here in terms of reading it. But just look, for example, as I go down a little bit here to CA 8, Court of Appeals 8, that's the 8th Circuit. All of you know we are within the 8th Circuit Court of Appeals. And this past year, one case was accepted by the Supreme Court and it was affirmed. And so 100% affirmation of the 8th Circuit Court of Appeals. Hard to generalize from one case, but what's interesting is about a half a dozen years ago, there was about a 2 or 3 year period where the 8th Circuit led the country in 0% affirmed opinions by the Supreme Court. Phrased another way, 100% of its cases were reversed. And it was clearly at a time where the 8th Circuit Court of Appeals and the U.S. Supreme Court were moving in different directions or looking at the constitutional and et al. Issues in different ways. By way of retirements, replacements at both the 8th Circuit and now at the Supreme Court, again, hard to generalize, but it's about 100%. I've seen it for the last couple of years. Conversely, look at CA9, which is California, Washington, Oregon, viewed as one of the most liberal courts, the 9th Circuit in the country. 10 cases accepted, overall only one affirmed. And then we look at states, cases coming up from the highest state appellate courts, 3 affirmed, 8 reversed, 27% affirmed rate. Overall, look at this, of the 77 decisions that were issued this year. We have 22 affirmed, 45 reversed, 33% affirmed. Again, underscoring the fact that oftentimes if a case is accepted by the Supreme Court, it generally means that they probably disagree with the lower court and are going to probably reverse it. Now, this is just a fun little statistic to throw in here. And I have to tell a quick story because it's a Ruth Bader Ginsburg story and I like it. Back in the 90s when I was teaching, I think a constitutional law class, a student raised her hand one day and she said, Professor Schultz, are there some justices, rephrase it. She said, how long does it take for the Supreme Court to issue an opinion after oral arguments have occurred? And then she asked, are there some justices who are quicker or faster than others? And I thought, well, that's a really good question. So it happened to be about 1998 or so, 99. I had 3 previous years where I could gather data on the Supreme Court where no justices had changed over in terms of how much time they had been there. And I calculated all the data, and what I found is for each of the 3 terms and overall, Ruth Bader Ginsburg was by far the fastest justice on the court. In case you're wondering, number 2 was Sandra Day O'Connor. So the 2 female justices were just blowing the doors off of all of their male colleagues. So I decided to write up just kind of a cutesy kind of article, got published in University of Minnesota's Constitutional Commentary. I think I called the title Justice Delayed, Justice Denied, Fastest Justice in the East. I refer to Ruth Bader Ginsburg as Top Gun, all the kind of cultural references today. Got it published, and then just for the heck of it, I sent her a copy of the article with brief notes
Professor Schultz, I'm going to jump in for a second. Can you hear me okay?
I can now.
Yeah, I'm sorry. We've got somebody whose mic is not muted. I'm not able to see who it is, but I'm just going to ask everybody. We were losing your voice because somebody's voice was covering yours. So please, everyone, mute your mics.
Okay. Am I okay now?
I believe you are. Thank you.
Okay. Okay, good. Okay. So anyhow, I got this piece published, concluding that she was the fastest justice on the Supreme Court back in the 90s, sent off the article to her, never expecting to hear back from her. And she writes me a wonderfully gracious letter, thanks me for it, points out in the letter that her daughter and granddaughter always complain that she's the slowest eater around. Pokiest, I think maybe the phrase is pokiest or something like that. And she then says in the letter that it's nice to know that my slowness in eating is made up by my pace of writing decisions. And I just thought it was a delightful letter. The next paragraph, she then explains why the other justices are not slow, that they're too busy reading opinions like hers, et cetera, et cetera. Gracious and nice. I tell that, A, because it's a wonderful story about her, I think, but two, up to the last days on her court, last term, Ginsburg is still the fastest justice on the court, turning around an opinion in 36 days. And I just throw Gorsuch in for the heck of it, although it's a very controversial case. But that's sort of my Ruth Bader Ginsburg story, that she remained consistent, at least with the speed of her opinion production right to the end. Okay. Chatter from the bench. We also know, and those of us who have made oral arguments before appellate tribunals, we are used to being peppered with questions, from the bench, whether it's the Minnesota Supreme Court, Court of Appeals, those of you who have done Eighth Circuit, Supreme Court, wherever it may be. And oftentimes it's kind of random. And we know at the Supreme Court level that the justices are famous for doing this. When Anton Scalia was on the court, he was famous for asking lots of questions. Once Sotomayor got on the court, Scalia and Sotomayor were competing for the most. We also know that Justice Thomas historically doesn't ask questions. In fact, he went 10 years without asking a question from the bench. Someone asked him once why he doesn't do that, and he said, I think it's rude. I would rather let the attorneys make their presentations. But anyhow, just for fun here, chatter from the bench. No surprise, we see his Sotomayor was at the top of the list. And you also had people such as, Breyer second in terms of chatter from the bench there. I also like to look at who agrees with whom on the court. And this is looking at percentage of times that justices agreed with one another in terms of split decisions. It's full, partial judgment. And just to sort of get you to look at it here, what this says, for example, is Chief Justice Roberts and Clarence Thomas were in agreement 55% of the time. Let me go to the next slide, and I'll highlight some stuff. So among all cases, and then I'm going to do split, among all cases, Roberts and Kavanaugh agreed 93% of the time. Ginsburg, Breyer, 93%. Alito, Thomas, 92%. Lowest agreements, Sotomayor, Thomas, 45, etc. This is just interesting from a strategic point of view. Are there blocks? Are there certain justices who seem to be, I don't want to quite say in lockstep together, but I don't know, when you get 93% of the time in agreement, that's pretty lockstep, and it might tell us something, especially here when I come back to it, that Kavanaugh and Roberts seeming to see the legal world eye to eye. And then voting alignment among justices in divided cases, Roberts, Kavanaugh still high, Ginsburg, Breyer, Alito, Thomas, and then look at, for example, the lowest agreements, Sotomayor and Thomas, 13%. They almost never agree. Makes you wonder, if they could agree on, I don't know, lunch plates or something like that. I don't know. 5-4 cases. These always are interesting to look at here. And if we go to the line here where it says OT 19, there were 13 5-4 opinions this past term. 21% of all the cases were 5-4. It broke down according to what we would call ideology, 92% of the time. In terms of did it flow along the lines of liberal versus conservative, and conservatives won 75% of those. Overall conservative victory was 69%. Put this in historic comparisons now. 15-year average. 21% are still over 15 years, 5-4, but the historic average was what? 76% ideological and 59% conservative victory. We can see signs, and even just doing a comparison of 19 to 18, we can see signs of the conservatives doing dramatically better on the bench and doing better on the court than they did a few years ago, or according to that historical average. Opinion writing, who's productive? Look at the majority opinions. It's pretty evenly balanced. Justice Roberts has done a good job of balancing them out. So he's written 7. Gorsuch wrote 7, and then a relatively easy distribution for the others. But what I find the most interesting is Justice Thomas. In terms of concurrence and dissents, Thomas may not be asking lots of questions, but he's certainly writing a lot of ink or producing a lot of ink in terms of his opinions, especially concurrences and dissents. And a lot of times those concurrences are taking him in a direction of saying, yes, I agree, but completely for different reasons than the majority is articulating. Majority rules. Who's in the majority the greatest amount of time or greatest percentage of the time? And if we look at it here, Justice Roberts is in the majority 97% of the time. In all cases, 95% in split, 92% in 5-4 cases. That speaks pretty significantly to a court where he seems to be in command, because many people think that the court last term was split with 4 liberals, 4 conservatives, and Justice Roberts as the swing. If that's an accurate description and these statistics bear it out, he clearly has had that important role. Again, Roberts as a swing justice, 90% plus in majority for all types of decisions. Most majority opinions, 7. Wrote the most 5-4 opinions, 4. Again, that seems to bode in the direction of saying he might have emerged as the swing justice this past term in an ideologically or somewhat ideologically balanced court. Although we do know long term he's voted more conservatively, and therefore the balance may be the fact that, as I mentioned before, of him trying to institutionally protect the court. Kavanaugh's impact overall in majority, 93% of the cases, wrote 4 of the 5-4 opinions, tied with Roberts for first. In majority, 89% for divided, most likely to agree with Roberts, least likely to agree with Sotomayor. Not sure what to make of it yet, but I just find it interesting that Roberts and Kavanaugh seem to have become, like I said, legal, I don't know what, bed buddies, or probably shouldn't use that phrase, but sort of legal companions in terms of deciding cases or how they look at the law. Kavanaugh Factor. Gorsuch did not change voting alignment of the court when replacing Scalia. Did Kavanaugh change the voting alignment? A little bit, he did. And again, keep this in mind when we now get to the fact that it's barring anything unforeseen, Amy Coney Barrett now replaces Ruth Bader Ginsburg. Does this move us into a, let's say, either a 5-3 in one court, with the 1 being Justice Roberts, or a 5-4 court? Will there even be a concept of there being a swing justice at this point going this year and going into the future, foreseeable future? I'm not sure. And then what happens when orals change? For the week of May 4th and May 11th, Supreme Court scheduled orals for telephone and live stream video. 10 cases were argued that had to be rescheduled because of the pandemic. And the procedure was changed. The orals would take place remotely. Lawyers would call in by telephone. And this is a dramatic change. Justices could not interrupt during the oral arguments. And what would happen instead is, after the presentations, starting with Justice Roberts, and then in terms of seniority, each of the justices would get to ask questions. So this is almost like what happened in the old days in the early 19th century before the Supreme Court, where it sort of took place this way. So the process was changed. What happened during those 2 weeks? Again, Thomas asked questions that other justices reacted to. So that was pretty interesting. Some have claimed, Tim Johnson, who teaches at the University of Minnesota Political Science Department, who studied this, he claims that Roberts cut off females and liberals to maintain the schedule. Possibly. I haven't seen the whole article yet. What's also interesting is how disconcerting some of this was for attorneys. For appellate attorneys who've trained to be before the justices, to see them in their eyes, to be ready to be peppered with questions, to be standing at a podium or a lectern. All this was strange. And they interviewed some of the attorneys who said, well, I went to work. I still was fully dressed. I had someone bring in a lectern so I could stand up, trying to, as much as possible, replicate the format. I think one of them said he also got pictures of the 9 justices and put them up in front of him so he'd have to look at them. Because what? We all know this. We're trained to do certain things. We're creatures of habit. And some of them just felt more comfortable this way. Of course, there were some mishaps. Justices forgetting to turn audio on and off, connectivity problems. And then during one of the oral arguments, there was audibly the sound of a flushed toilet. Now, no one has confessed to this. One wonders where justice was being dispensed when that sound occurred. I guess what inquiring minds want to know, but we'll never find out. Did it affect the outcome of the cases? These were the 10 cases that were remotely argued. I gave a quick eyeball to these in terms of what the cases were about and so forth, and I didn't discern in here a pattern that changed in terms of how the cases might have been decided as a result of it being distance. But some others are still looking into this. I'm not sure what you can conclude out of 10 cases. But before I get to this, but what I would say is that with the possibility perhaps being again this term, that there might be some cases that are going to be done maybe remotely again, or maybe the Supreme Court's going to adjust how it does remote cases. We may want to be thinking about lessons learned from the orals. And then I just have a very small number of cases that I think are, for my selection, that are important. Of course, all of the decisions are important, but I wanted to highlight about 5 of them here. Ramos versus Louisiana, which I actually think is one of the more interesting ones this term, was all about what? It was about the Supreme Court overturning an old decision. In 1972, the Supreme Court said that in fact you could do criminal convictions, criminal trials with and have guilty verdicts rendered with non-unanimous juries. Ramos overturns that. Trump versus Mazars and Trump versus Vance are the 2 cases regarding the request for the president's tax returns. Mazars is the case where the Supreme Court said that, yes, in theory, Congress may get Trump's taxes. However, lower court did not give sufficient attention to the separation of powers issues. Send her back to lower court. Trump versus Vance. Cyrus Vance Jr. Is the Manhattan Borough District Attorney. He's investigating tax and perhaps banking fraud. A grand jury requested Trump's tax records. The Supreme Court ruled that, yes, in theory, they're entitled to them. I like the decision that Justice Roberts wrote where he said, it's a long-standing tradition in American law that everybody is entitled to everybody else's evidence, and treated the taxes as just an evidentiary type of issue. That's, of course, still being fought out. Chiafalo versus Washington, Colorado Department of State versus Baca are timely for the election year. They involve the situation of whether states could find and bind electors to the Electoral College and make sure they vote the way they're supposed to, so-called faithless electors. And the answer is yes. And then McGirt versus Oklahoma is clearly the most misunderstood case of the entire year. Much of eastern Oklahoma, it's a case involving the Major Crimes Act and where crimes must be heard, whether in state or federal court. And here there was an alleged crime that took place in parts of eastern Oklahoma. And what the court said is that since that part of eastern Oklahoma still remained in what was part of Native American land, this could be a case tried in federal court. What wound up happening is all the media misreported it and said eastern Oklahoma remains Native American land. The court didn't say that. Now, Marshall's going to have a few other cases. I should just mention there was also the major abortion case that came out of Louisiana, where the Supreme Court struck down Louisiana restrictions on pregnancies, or on terminating pregnancies, specifically striking down some procedures that would require hospital privileges, location of clinics near hospitals. This was a fairly big surprise. People thought this was going to be the big one, a breakthrough on reproductive rights and abortion. All right, those are mine. And let me stop sharing my screen to make sure I get this right. I think that's correct. Hold on. Okay, and I will turn it over to Marshall.
Good afternoon. It's a pleasure to be here sharing this presentation with Professor Schultz. My name is Marshall Tannick, and I'm going to be reviewing 5 diverse decisions of the Supreme Court during the last term. They're not necessarily all of the most important decisions, although, as David indicated, every decision is important, but I thought they reflect certain patterns and trends that are worth commenting on. Before I do that, I want to just follow up on a couple points that David made. My understanding was that the first 2 weeks, which just concluded yesterday, of the current Supreme Court term were also conducted by telephone, as they did last spring. I don't know what they have planned for the rest of this month or the rest of this term, but I doubt that they're going to be having live presentations, at least in the immediate future. So I suspect they'll continue doing the telephone remote type of hearings. Furthermore, one wonders if and when they're ever going to come into the 21st century. They barely got into the 20th century and do Zoom visual court hearings. Given the court's historic telegenic aversion, it may never happen, but the telephone process certainly is awkward, and we all know that trial courts and appellate courts around the country, including Minnesota, have done fairly well with Zoom visual video type of hearings, but the Supreme Court hasn't gotten there yet. They're still working on the telephone, but at least they've progressed from the telegraph to the telephone. David commented a little bit about swing votes and the 5-4 cases. It always reminds me of, I don't remember what term it was. I think it was maybe 2014 or 15, 5, 6, 7 years ago, when the court had 21 5-4 decisions in that particular term. And Anthony Kennedy was the 5th vote in each of those cases. Each of the 5-4 decisions, 21 to 5-4 decisions, Kennedy was in the majority in all 21 of them, generally with the conservative wing, occasionally with the so-called liberal wing. But that's really a swing vote when you're 21 for 21. David commented on his note to Justice Ginsburg. My wife, Kathy Gordon, and I wrote a piece on Justice Ginsburg a couple of years ago after we had met her at a Supreme Court function. And our article, which was published in Bench and Bar, if you want to look it up, it was in, I think, the January edition of Bench and Bar 2 years ago, was about her role in Minnesota cases that have come before the Supreme Court during her tenure there. And we analyzed majority Minnesota cases were before the Supreme Court during her time, and I sent her a copy of the article and wrote her a little note. Unfortunately, I never got a reply, and I was still waiting for it. So David's the one up on me. At least he got a reply from Justice Ginsburg. I didn't. As far as the toilet flushing, I feel your pain, because I've had several cases myself, including one recently where I felt that my appellate argument went down the toilet itself. So I kind of get it. But moving on to my 5 cases, I'm going to start with a case that I call the Seinfeld case, and I refer to it as that. It's the New York State Rifle and Pistol Association versus City of New York. And I call it a Seinfeld case not because it happened in the city of New York where Seinfeld took place, but because it's about nothing. It's a case about nothing. Well, not quite. It's an important case, but ultimately the decision was a non-decision. The holding of the case was not to make a ruling at all. The case involved a rather unusual, I guess unique, New York ordinance that prohibited lawful gun owners from taking guns outside of the city. A couple of gun owners organizations sued, claiming it was a violation of the Second Amendment. So it's a Second Amendment right to bear arms case. The argument against the ordinance made by the gun owners was that this prohibits individuals from taking guns outside the city to go to their own homes if they have second homes, going upstate. It even prohibits them going out of the city to do target practice, let alone hunting. But they can't do target practice outside the city because there are no places to do target shooting in the city of New York unless you want to shoot at humans. So there were a number of practical reasons why they argued that we should be able to take guns outside the city. The 2 lower courts, the federal trial court and the federal appellate court, upheld the law under a Second Amendment challenge. It reached the Supreme Court. The Supreme Court took certiorari in the case, and it was created a lot of buzz because it was the first Second Amendment case that the court took since the Heller and McDonald cases back a decade ago, 2009 and 2010, in which they gave broad reading to the Second Amendment rights to bear arms. So court watchers and others were very eager and interested in how the court would come down now, especially with its new composition. But it never got that opportunity because while the case was pending before the Supreme Court, the city repealed it. And it explicitly did so because of the fear by the city officials and gun safety advocates who were the promoters of the law. They feared that the Supreme Court was going to reverse the lower court decisions, invalidate the law, and also come up with some rhetoric and reasoning that would be very antagonistic to the position of gun safety advocates and be further supportive of Second Amendment rights. So discretion being the better part of valor, the city repealed the measure. That still begged the question of what to do, what the Supreme Court should do with the case. And the issue before the court was, does the repeal of this measure that was challenged render the case moot? And the court said it did, by a ruling authored by Chief Justice Roberts. It was not a per curiam decision, that's my mistake. It was a written decision by Justice Roberts for the majority of the court. He held that the case was moot because the ordinance had been repealed. The key phrase in his decision was, "We do not here decide the disputes." There was not a Article 3 case or controversy since the law had been repealed. The case was moot. The court did, however, remand the case for more pleadings and to, quote, develop the record on possible damages. But as a practical matter, the case became moot. The claimants asserted at the Supreme Court level a claim for damages. They never asserted damages in the lower court proceedings. They never amended their complaint. But when they got to the Supreme Court, they said, "Oh yeah, we want to seek damages too." So Roberts said, "Well, okay, we'll send it back, and you can see about damages, but as far as the merits, we're not going to pass upon it." So essentially, the air was taken out of the balloon. The case is, as a practical matter, over, and it's moot. The dissent was interesting. Justice Alito led the dissenting group, and he would have ruled the law unconstitutional. It says constitutional. That's a typographical mistake. It's my fault. Alito was quite adamant that the law was unconstitutional on the merits. It violated the Second Amendment, and had he been in the majority, there would have been a very striking Second Amendment right to bear arms decision written by him. He was joined by Gorsuch and Thomas, and Alito also went out of his way, I think, to chastise the court for allowing itself to be, quote, manipulated, unquote, by the city by repealing the measure. He was kind of scheming about how the city should not have gotten away with repealing the measure while the case was pending before the Supreme Court. Justice Kavanaugh joined the dissenters on the merits. So Kavanaugh would have also joined the other three dissenters in holding that the law was unconstitutional under the Second Amendment, but he agreed with the majority that the case was moot. So technically, it was a 6-3 mootness ruling. An interesting significance of the case is that it could provide somewhat of a template for in the future for high-profile, volatile legislation in connection with not only Second Amendment issues, but reproductive rights issues and things of that nature, where there's a challenge made to a statute or an ordinance. And if the Supreme Court takes certiorari on a case like that, the proponents of those laws might follow the New York approach and say, well, for fear of getting the law overturned by the high court and for fear of creating bad law, we'll just repeal the law. The chances of the law getting to the Supreme Court, as David indicated, are very slight, 1% or less of cases are heard, half of a 1%. So advocates of particular measures might say, let's pass this law, and in the event that the Supreme Court takes certiorari on it, well, we can always repeal it later on and avoid a decision on the merits and live to fight another day. So we'll have to see if that plays out, particularly in connection with some of the gun-related ordinances, such as the notification requirements, the red flag laws, the warning laws, and things of that nature. We may see in Minnesota. In Minnesota, we've had two of those laws passed. Two of the laws passed in the House of Representatives, but the Senate refused to go along. But depending upon the composition of our state legislature after the election, we may see some gun safety measures passed here. And if they wind their way up to the Supreme Court, the legislature may say, hey, wait a minute, we don't want the Supreme Court to rule on our laws, and we'll think about repealing them and follow the New York pattern here. But so the case is somewhat significant in that sense. There have been 3 mootness rulings by the federal, by the 8th Circuit and the Minnesota Appellate Court since this decision came down in different issues. They did not involve Second Amendment issues, but it's interesting that the mootness argument has been made and succeeded in 3 federal 8th Circuit and Minnesota court cases since May, since this case came down. But it is a significant case. It's an interesting case, and one particular reason I wanted to review it in this format is because it allows me to use a cartoon of Elmer Fudd. I don't get a chance to use that very often. The next case is kind of a real backwater of the law case, but I think it has some real jurisprudential and political significance. The case is SELA Law versus Consumer Protection Bureau. That's the Elizabeth Warren Consumer Protection Agency that she essentially created, not herself, but she was the advocate back in the Obama administration of creating this agency that would essentially be a watchdog agency with some degree of oversight. Its remedies are somewhat limited, but it's a federal watchdog agency that oversees debt collection in some financial institutions. It had some real oomph in the Obama administration. It has not had done much at all during the Trump administration. But the agency was investigating a California debt collection law firm under one of its investigatory provisions to see if it complied with the various procedures that have to be followed in order to do debt collection. As we all know, there's a number of different procedures as to how you notify debtors and what you can say and what you can't say and when you can say it and so on and so forth. And therefore, the investigation focused on a particular law firm in California. The law firm challenged the constitutionality of the law on grounds that the law limits the ability to remove the director of the agency by the president only for reasons of cause. So the statute provides that the director of the agency can be removed only by the president, but only for cause. The law firm, even though this is not a termination case, the case did not involve the issue of terminating the director of the agency, but the law firm argued that because the structure of the agency limited termination for cause, that constituted a violation of separation of powers and therefore negated the constitutionality of the law as a whole. So I have an interesting posture of the case. The law firm that was being investigated claimed that the law was unconstitutional because of its provisions as to how the executive director can be terminated, which had nothing to do with the debt collection practice itself. So the issue was a separation of powers issue, and the court, in a 5-4 split, held that reversed the lower court rulings and held the law was unconstitutional. The Chief Justice authored the majority opinion, and he ruled or reasoned that by creating an agency whose head can only be removed for cause, the statute violates the separation of powers by limiting the power of the president. That was the dividing line for the majority. Because the presidential authority is limited here by Congress, the law violates the separation of powers, and therefore the law is unconstitutional. The liberal dissenters took a different view, and they opined that the Congress has broad authority to, quote, experiment with different types of administrative forms, but that didn't carry the day. The significance to the case is it's a reflection of the broad, expansive view of presidential authority. Now, while this case is a rather idiosyncratic case in itself, the underlying reasoning suggests the court's willingness to grant broad powers to the executive, and that's consistent with other rulings of this court, in particular of Justice Roberts. Not quite the unitary presidency promoted by Attorney General Barr, but nevertheless a broad view of presidential powers, as reflected by Justice Roberts in his majority decision upholding the Muslim ban the previous term. In the Muslim ban case, the argument was made that the Muslim ban was unconstitutional because it was based on religious grounds, and the basis for that was a number of the comments, the remarks that President Trump made in the campaign and even after he was elected on the religious nature of the Muslim ban. Justice Roberts took those into account, but he said, nonetheless, we view this as a matter of presidential authority, and the president has virtually unquestioned authority in dealing with matters of immigration and foreign affairs, and therefore they upheld the Muslim ban. And that same kind of reasoning underlies the Sela law firm case, insofar as it grants broad executive powers to the president. From a historical standpoint, the case is somewhat significant because it's reminiscent of the impeachment battle over Andrew Johnson right after the Civil War. After Johnson succeeded the assassinated President Lincoln, he was, as we all recall, impeached, and he managed to avoid being removed from office by one vote. The basis for the Andrew Johnson impeachment was the Tenure of Office Act. It was a statute that was enacted by Congress right after the Civil War that precluded the president from removing members of the cabinet or other high executive officers without congressional approval. And the radical Republicans who control Congress at that time were very wary, and rightfully so, of Johnson and his, and in particular, Johnson wanted to remove did remove Secretary of War Stanton. The radical Republicans didn't like that idea, and because it violated the Tenure of Office Act, and they impeached him for that reason. And Johnson ultimately escaped the removal from office by one vote. But in that case, the question there was, in the impeachment proceeding, the question was, to what extent should presidential authority in an appointment process, appointing or discharging executive officers be allowed? And in this case deals with the same issue. The next case is the marquee case of the term, Bostock versus Clayton County. That's the LGBTQ employment discrimination case that everybody has heard of. It was probably the most watched case of the term, not only for its jurisprudential factors, but because it's a case that the public at large can easily understand. There's no complications to it, at least in understanding what was going on, and of course it has a great deal of social significance. The issue in the case was whether the prohibition of discrimination based on sex in the 1964 Civil Rights Act extends to the LGBT community. This was a discharge case. Actually, it was 3 discharge cases. The cases came to the court due to a split in the circuits on 3 different cases. All the cases involved LGBT employees. So this is an employment discrimination case. Two of them were gay, one was transgender. One was a county child welfare worker, one was a mortician in private sector, and one was a parachute diving instructor. They all were fired, and the cases came to the court on Rule 12 motions, so there were no facts in dispute for purposes of the court's determination. For purposes of the court's ruling, it was conceded that they were all fired because of their sexual orientation. Now, whether that plays out in the trial proceedings remains to be seen, but the issue was, is firing an individual because of their sexual orientation, I almost said sexual preference, but I don't want to, violative of the sex discrimination provision of the 1964 Civil Rights Act. Also, as a footnote, one might want to observe that this is the first case, I believe, maybe Professor Schultz can correct me on this, I think this is the first time the Supreme Court has had a case involving a parachute diving instructor.
I think it is the very first one. They decided to leap into this case.
Right, thank you. The court ruled 6-3 with Justice Gorsuch writing the majority decision that the sex discrimination provision of the 64 Civil Rights Act prohibits firing an employee, and presumably refusing to hire an employee by the same token, because of their sexual orientation. Chief Justice Roberts joined the majority, so it was a 6-3 decision. And Gorsuch, this is a statutory interpretation case. It has nothing to do with constitutional law. The court was asked to and did interpret the meaning of the term sex discrimination in the 64 Civil Rights Act. And it gave Justice Gorsuch a chance to deploy his favorite judicial philosophy, textualism. Have we heard much about that this week? Yeah. Gorsuch is an advocate of textualism, which, depending upon how you view it, essentially means interpreting laws according to the words in the law as they were understood or meant by the proponents or drafters of the law or the constitutional provision. And Judge Amy Coney Barrett commented at great length in the hearing this week about her adherence to textualism. Gorsuch is considered the leading textualist in this court. Scalia was one too of sorts, but Gorsuch is a pure textualist, and he wrote a book last year about that topic, about interpreting laws and constitutional provisions according to textualism. Gorsuch wrote the book literally and figuratively on it. I don't think it was a bestseller necessarily, but it explains the philosophy of textualism, which Judge Barrett commented on and was asked about in the hearings this week. Justice Gorsuch reasoned that the word sex he acknowledged, and all the justices acknowledged, that when the law was passed in 1964, nobody was thinking about how it might affect LGBTQ individuals. Indeed, back then, it wasn't even a blip on the radar screen. This is 5 years before Stonewall, for that matter. So Justice Gorsuch acknowledged that no one gave any thought to that, but given the textualism of the statute, he said it is, quote, impossible to discriminate against an LGBTQ person, quote, without discriminating based on sex. In other words, sex is woven into any decision made about hiring or firing an individual because of their sexual orientation. The dissenters, Alito, Thomas, and Kavanaugh, complained that Congress never intended such an interpretation, and they all fell over themselves backwards, saying, we don't support discrimination based on sexual orientation, and we don't advocate that, but we think this is a matter that should go to Congress. Congress didn't address it in 1964, and we shouldn't write or rewrite the law for it. The significance is obviously a major stride for LGBTQ community in terms of employment, hiring and firing. A number of issues remain in the wake, of course: housing, healthcare, adoption, participation in intergender athletics. Those still issues are wide open, but at least as far as the employment status of the case has been resolved at the federal level. Interestingly, it's not the end of the Obergefell reasoning either. The Obergefell reasoning kind of popped up again. The same-sex marriage case popped up again last week before the Supreme Court. The case was the Kim Davis case. You may remember that she was the county clerk in Kentucky who refused to issue a marriage license to marry a gay couple after Obergefell on grounds that her religious beliefs prohibited her from carrying out her duty to give a marriage license to a lawfully married gay couple. She took that to the Supreme Court. Essentially, it wasn't a challenge to Obergefell, but it certainly has Obergefell themes to it. The Supreme Court denied certiorari, but Justice Alito, joined by Justice Thomas, wrote a decision advocating taking certiorari, and the terminology of their dissent strongly suggested that they're interested in revisiting the Obergefell case and revisiting the whole issue of same-sex marriage, and at a minimum, trying to rein in the rights of LGBT individuals in other areas besides employment. So we'll have to see what happens there. It's kind of a Yogi Berra case in a sense. It's never over until it's over. The last two cases I'll kind of combine together because I'm running short on time. They're both religious rights cases, and they both involve clashes between the Establishment Clause under the First Amendment and the Free Exercise Clause. A number of these cases have come before the court during Justice Roberts' tenure, and I think going back to at least the last 10 years, and maybe Professor Schultz can correct me if I'm wrong, but I think there's been nary a case before the Supreme Court in which a free exercise claim has been raised and has not been upheld by the Supreme Court. I think there was one, but I don't remember which case it was. But if you're a betting person and a free exercise clause comes before the Supreme Court, in which the argument is that whatever measures in being challenged infringes on the free exercise of religion, if you're betting on it, take the over on that, because the Supreme Court has consistently taken those cases, they've looked for those cases, and they've consistently upheld the free exercise claims, which clash with the establishment claims. The argument on the free exercise end of these cases, of course, is that these measures, these restrictions or measures somehow infringe on freedom of exercise of religion, versus the establishment clause, which provides for a secularity in government action. But the free exercise clauses, the claims tend to prevail, and they did in these two cases. Our Lady of Guadalupe School versus Morrison Barra was an employment case. The case was an extension of a 2012 decision by the court called the Hosanna Doctrine. The Hosanna Doctrine basically allows religious institutions, including schools, to take action that is inconsistent with the anti-discrimination laws if they're predicated on religious grounds. In other words, it gives a free pass for religious institutions to discriminate if their discrimination is due to their religious views. This case involved two teachers at religious institutions, and one of them sued for age discrimination, one for disability discrimination after they were fired. The school defended its position by asserting that the Federal Civil Rights Act and the Age Discrimination and Employment Act, the federal discrimination laws don't apply to it because they were acting on their religious views and should be exempt. And while the lower courts held that way, the Supreme Court did not, and they ruled in favor of the schools. They reversed the lower court ruling. It was a 7-2 decision written by Justice Alito, and it included Kagan and Breyer, two of the so-called liberals. They joined the court in holding that the so-called ministerial exception under Hosanna applies to school teachers in religious institutions, even though, as the dissenters pointed out, those teachers taught primarily secular subjects. But the court's reasoning was, we don't want to interfere with any kind of religious or theocratic views of a school or a religious institution, notwithstanding the fact that they were terminating employees who did not have religious positions in the school. So it was a broad extension of the Hosanna ministerial exception doctrine, which pretty much gives religious institutions free rein to discriminate in connection with hiring and firing decisions. A broad interpretation of the free exercise clause that trumps, no pun intended, the federal civil rights laws. The last case is another religious case that even more clearly pits the free exercise against the Establishment Clause doctrine. This is a Montana case, Espinoza versus Montana Department of Revenue. Montana had a state tuition program that provided scholarships for public school students only, but excluded students at religious schools. 3 parents of the parochial students sued and said that by limiting public funding to public school students, but prohibiting parochial students from receiving these state scholarships, the law violates the free exercise clause of the First Amendment. The state Supreme Court disagreed, and it held that the Establishment Clause necessitates that kind of separation, particularly because Montana, like most states, have a state constitutional provision that bars financial aid to religious institutions. So the issue was, did the parents of parochial students have a free exercise claim to be treated the same as public students, or would giving public aid to parochial students infringe the Establishment Clause? The court held in a 5-4 decision written by Justice Roberts, and this was a classic conservative liberal split, that the free exercise clause prevails over the Establishment Clause. Justice Roberts wrote that denying public funding to parochial students for scholarships constitutes unequal treatment or imposes a special disability on the basis of religious status. That violates the free exercise clause of the First Amendment, which trumps, no pun intended again, the Establishment Clause prohibition of public aid to religious schools. The dissenters picked up on that point and said, what you've done here is elevate free expression of religion clause over the Establishment Clause, to which the majority said, yeah, bingo, we did. You got it right, dissenters. That's exactly what we did, and that's what we've been doing for the last decade, and perhaps we'll continue to do even with greater vigor if and when Judge Cooney Barrett is seated on the court. Obviously, there was a great deal of discussion during the confirmation hearing about her views on matters of that type, which she avoided expressing opinions on. But we're probably going to see the court's going to probably take on more of these free exercise cases, and if past the precedent as any prologue, they're going to continue to uphold these free exercise claims over establishment claims. Incidentally, this case harkens back to a Minnesota case, the parochial aid statute. Minnesota, back in the early 1980s, passed a law giving Minnesota parents limited tax credits, state income tax credits, for parochial school tuition. In that case, the court upheld the Minnesota program by a 5-4 ruling, and this is sort of the son or daughter of that case, reflecting the Justice Roberts Court's broad view of the free exercise clause. So those are 5 cases that I think are noteworthy for different reasons, and I think they all, in one way or another, reflect patterns and trends that we're going to see played out in the years ahead. So that's my presentation, and we're probably out of time, but I'd be happy to try to take any questions you might have, and I'm sure Professor Schultz would as well.
We're looking for questions if anybody has them.
Not seeing any in the chat yet. If anyone has a question, please go ahead and enter it in the chat and we can relay it.
Well, I have a question for Professor Schultz. We really didn't touch on this, but we talked about kind of the past. What do we see upcoming here? What are some of the hot button cases that are on the court's docket for this year?
Well, there's no question that I think one of the biggest ones, and this is referred to in the presidential debates recently, is that there is a case before the Supreme Court regarding the Affordable Care Act or Obamacare. I think that's the most significant one that's coming up, where the Trump administration has asked that the Supreme Court reconsider its decision. Basically, what happened is that the Supreme Court, when it upheld it, when Justice Roberts upheld the ACA several years ago, it did so under the what's called the tax for the general welfare clause, and said that tax for the general welfare, or rather the requirement to have a health insurance was constitutional in the sense that if you didn't get the health insurance, you could be taxed in lieu of it. Well, with the original mandate, or rather with that what's called the individual mandate having been repealed during the tax reform under the first year of the Trump administration, the argument now is that this act is no longer constitutional, and a lower court has struck the entire ACA down as unconstitutional. I think that's the most significant case coming up before the Supreme Court this year. What do you see coming up?
Well, I haven't seen much. I just haven't had a chance to see which cases they've taken. I think they've, as of the last time I looked, they've added 29 cases to their docket, which is probably about half their docket. They might dip under 60 this year. But there are some cases that are going through the circuit courts that raise issues concerning the extent and scope of the Obergefell versus Hodges same-sex marriage doctrine. None of them are challenging the same-sex marriage decision itself, but they involve ramifications as they involve ramifications like the Bostock versus Clayton case of the extent to which LGBTQ rights are going to be recognized constitutionally or statutorily in connection with housing and adoptions and various other issues. So I suspect that within this term or the next term, we're going to see a revisiting of at least the underlying premises of Obergefell in connection with the extension or limitation of LGBTQ rights.
No, I think you're right. And I also wonder if after this past term with Bostock, we're sort of at an impasse now, or a limit. I'm not sure what the word I'm looking for, in terms of how far the Supreme Court's going to go in the near future on LGBTQ issues. I think that's probably right. The question now becomes, are they going to retrench a little bit?
Well, time will tell, but I guess our time is up. So thank you all for your patience, and I hope you learned a little bit about what the Supreme Court was up to last term and what they're going to be up to now. And I guess it's time to leave. We can all go to the bathroom now and go to the toilet, right?
And have the Supreme flush. Yes, correct.
Thank you both so much.